And the next panel is a panel that I'm very excited about. It is the Emerging Leaders section of the Florida Bar and the work comp a part of the Florida Bar. The emerging leaders are our next generation, and they are going to give us their perspective on the practice, and I think it's a perspective we all desperately need to hear. I will be perfectly honest. This group right here was kind of the inspiration for doing a whole perspectives panel presentation, or the theme here of today. So very excited about that. They are going to be moderated by the Honorable Jonathan Walker from Pensacola. Please give it up for the emerging leaders.
Thank you very much, Judge Hedler. I think you can probably tell by my hair color I am probably not a member of the emerging leaders. But it has been just a real pleasure to get to know everyone on this panel. They are just a super group. Our intent today, well, our topic today is actually emerging leaders in the use of litigation tactics in practice. We're going to be touching on those particularities, if you will, for the first 30 minutes. And thereafter, we're going to turn to a broader issue, which is professionalism. And within that term, we're going to hone down to the word professional. And what does it mean to be a professional in this day and age as an emerging leader? And I think you're going to be excited to hear some of their viewpoints. I know I was really educated, and it's just been a great experience. But with that said, what we're going to do, we're going to break it down. We're going to have, first of all, we're going to do the introductions, and I'm actually going to let them introduce themselves. As you know, sometimes you will hear a voice, and you won't always know what they look like, especially if you're an adjuster in our audience. So I wanted them to kind of introduce themselves, so sometimes maybe you can put a face with a voice. So I'm going to start with Megan to my immediate left.
I'm Megan Oliva. I've been practicing since 2018, and I am an associate at Bickler Longo.
I am Elaura Hodgetts. I am an associate at McConaughey Coonrod, and I've been practicing since 2018 defense.
I'm Ryan Knight. I'm a partner at Euclides Gelman down in our Miami, Fort Lauderdale office. I've been practicing since 2015.
And I'm Bryan Greenberg. Also been practicing since 2015, 2016. Claimant attorney down in Southwest Florida.
All right, thank you guys. What we're going to do, we're going to start with Elaura and Megan, and they're going to talk to us about motion practiced by the newer attorney. Go ahead, guys.
Well, we love motions, right? An opportunity to make our legal arguments, and so 60Q-6.115 subsection 1, the big thing that we were asked to address is how do we personally confer with the other side when we are making our motions. I prefer to call my opposing counsel. Oftentimes, unfortunately, I'm sent to voicemail or for whatever reason can't reach them. So I send an email, and more often than not, 99% of the time there is an objection. But on the rare occasion we can resolve it, which is nice. But that not too often is what we see.
Yeah. Similar to Megan, I will attempt calling. I will even call multiple times, and then I will email with a drafted motion and give kind of a timeline, say, hey, look, I want to file this by XYZ date, time, end of business. I have been on the receiving end of drafted motions, do you object to this? And then as I'm typing out my objection, 4 minutes later, it's filed. So I try to give some sort of notice as a courtesy generally. And like Megan said, sometimes you can actually work out the issue, but then other times you kind of just have to file it, let it lie, and then maybe it gets resolved before you have to go to some sort of hearing or a decision gets made. But I do try to confer as much as possible and try to get a response, but sometimes you just get a deadline, unfortunately.
Do either of you confer via text? And if
No.
so, is there a generational divide with that?
I have not. No.
I have not. I mean, I actually prefer it when the other attorneys have my cell phone number, just because you don't have to go through the office, and sometimes I'm not available. So if you call me on my cell phone, I obviously don't give my cell phone numbers to clients, but I do prefer, you have a direct line to me, you don't have to go through my office. And so text I haven't gotten, but I certainly always appreciate a call on my personal cell phone. I don't know how many other people would agree with that, but I appreciate it because it's a lot faster, in my opinion.
I think it depends. I mean, hopefully the people in this room that are familiar with me think I'm friendly and approachable. But with that said, that doesn't necessarily mean that I want to talk on the phone about every single issue, especially if it's something simple. And the other reason that sometimes by phone is not my preferred approach is because oftentimes we're doing 10, 12 things at once, 10 things to do before we leave the office. So to shoot out a quick email to the attorney that you have a good relationship anyway, saying, hey, we got to get this filed, do you object? Maybe a text follow-up. I like things being in the file. I like our staff being able to see what I did. So sometimes phone call, although it's, again, friendly and all that sort of stuff, sometimes I don't do that on purpose. And it's not because I'm trying to be mean or don't want to talk to anyone. It's usually more of an efficiency thing for me.
I think it goes to how complicated the motion is or the issue is that's being discussed. And I think there is a little bit of a generational aspect to it. There are people down by me that I work with all the time. We're similar in age. If it's a motion to reschedule within 210 or something like that, I think they're more apt to reach out to me via text because I'm on a phone call or doing whatever. But certainly something more substantive, a motion in limine, we're not going to work that out via text. That's got to be done via
Right.
email.
Yeah, certainly. I agree.
I think you guys were also going to talk to us about depositions for discovery and for admission at trial.
Yes, so depositions are always an exciting thing these days, especially via Zoom. They've brought some interesting, issues
I would say that,
forward. Of course, with the claimant deposition and then the employer representative, their depositions can come in really regardless of the use. There's a couple cases, Kelly or Keeley versus Webb, says that it's the prerogative of the party to use an adverse party's deposition, notwithstanding that the deponent is available to testify at trial. There's the Canales versus Campagna de Vapores Relma case, which says that it's reversible error to not admit the deposition of a defendant representative into evidence and to limit admissibility solely for impeachment purposes. With everything being on Zoom these days, I feel like, unfortunately, things have gotten a little bit more casual. Regardless of how many times I tell my clients, you need to show up, look professional. I know you're doing this from your home, from your kitchen table probably, but please, put on a jacket. If you don't have a suit, wear a collared shirt, look professional. And no matter how many times I do that, sometimes I end up seeing a client on Zoom in their pajamas.
Laying on the couch.
Exactly, and so it's no matter how many times I tell my clients, unfortunately, I see it pretty often. I think with the Zoom, even hearings, where I tell them 10 times, you're gonna be in front of a judge, please, this is your time, this is your case, you wanna put your best foot forward. Still, a lot of it goes by so many of my clients, and it really is important, and I think obviously putting a professional face on for the client. I mean, of course, I'm never in my pajamas, but especially for a client who's going in front of a judge, asking the judge to award them benefits, I think it's important for them to put on a professional look.
Certainly. I think that Zoom depositions have really kind of spiced up depositions, I would say, from maybe a defense perspective, maybe just a human perspective. But it's really a lot more distracting than you might initially think, because you're taking somebody's testimony, but you're also kind of focusing on the view that you have right here. This is how someone's testifying, and they are doing this, or they're walking around, and it's like, oh, look, you're outside, and do you own that property that's there? I see that we're walking those steps. Did you have an issue walking those steps up to your porch? Oh yeah, no, it hurts all the time. So I mean, you just kind of, it really elicits like a lot of other questions that you might not have the opportunity or thought to ask because that person isn't in the room with you.
And there's the, hey, honey, do you remember what, you know?
Yes.
Oh, stop, she's not testifying.
She's not
part of
testifying.
this.
Yes.
I
Is
know
there
she's just
anyone-
right there in the kitchen too, but
Is there anyone else in the room with you? Can you please tell them to exit the room? They're not supposed to be testifying for you. And so it makes things really, really interesting. To Megan's point about, this is still kind of a court proceeding. You're still supposed to dress professionally. I've seen the pajamas. I've seen the tank top. I've seen the shirtless.
I had somebody in the drive-thru at McDonald's when he logged on to a Zoom depot. That was
Okay.
my favorite so far.
Okay, that's a new one for me.
Yep.
I haven't seen that. I
Yep,
haven't seen
drive-thru.
that.
And it's not just on the claimant side, I will say. I've seen adjusters, it looks like pajamas, right? So I don't think it's just the claimant side. I think it's all parties, and so, and with Zoom, I think there's also a lot of tech issues. I don't know about you guys, but I feel like I'm constantly dealing with tech issues with my clients. They log on, but their audio doesn't work, or they log on and their audio does work, but their video doesn't work. And I found that something that's really effective for me is setting up a Zoom call with my clients a couple days before their deposition or whatever it is that's via Zoom, just so that we can make sure that the Zoom is working. It's not a 100% solve, but I do find it to be very effective.
Yeah, no, I would agree. So being a practitioner in the Panhandle, there are a lot of rural injured workers that we take depositions of. I appreciate the claimant's attorneys that have these workers come into their offices to be deposed, because otherwise you are facing spotty internet connections. And that means that the deposition is going to take at least 50% longer, because I'm going to have to ask every single question again. I'm going to have to ask this person to repeat themselves. And, the last panel was talking about, look, injured workers don't necessarily have 3 hours of their day to just kind of cut out from work and then come and do this proceeding. Completely understand that. But if that's the case, then I would say planning on the front end to see where your client lives, perhaps. Similar to defense, right? You plan on the front end. It's like, hey, come in, we're gonna prep this time, and then we're going to do the proceeding at this time. Makes it a lot smoother, and it saves you time, and it saves me time, and it saves your client time.
Yeah, we don't get paid for that time either, so we want it to go smoothly and quickly and
You get
last
paid
out.
at the end.
Hopefully.
Yeah.
The worst I've had on Zoom so far was just somebody smoking a cigarette, and it really is amazing. I could tell a lot of stories about clients that had a lot of warts on their case, and we were able to dress them up as, by the time we get to trial, the judge has no idea. Sometimes the defense attorney has no idea because they took the deposition over Zoom and they haven't had a chance to see the person, at the deposition like they normally would. But all those things are a lot harder when they're at home in their kitchen on Zoom. And even if we talk about, how to prepare and how to present, it's still, there's always a chance it doesn't go perfectly to plan. So it is an interesting dynamic, and it makes a lot of things way better. It makes a lot of things way more difficult or way more risky from a case standpoint, really.
I mean, that kind of ties into what the previous panel was talking about with the video depositions, though, because obviously we in the depot see all this, but I'm not sure how much of that is really coming across in the transcript if the claimant's dressed poorly or wandering around or smoking a cigarette, unless we're calling attention to it on the transcript. But even then, it's going to be one line, whereas in a video depot, it's going to be much more, I think, impactful.
Put the cigarette out?
Yeah, exactly. Yeah.
I do that occasionally for expert depositions when I'm really trying to attack their credibility. Especially with it being on Zoom already, you don't have to have somebody go to their office, set up a video camera in front of their face. So I find that Zoom is really helpful in that way, because they can just record it, and then you can submit it to the judge. So I've found that to be very helpful.
Before we move on to Bryan and Ryan, let me ask you guys a question, and this is your opportunity to talk to the judges. When we come to the Zoom hearings, and we have those, are there any pieces of advice, anything that we can do on the front end to make your lives easier when you come onto a Zoom hearing?
Our Zoom hearings have been really smooth.
Good.
I'm always pleasantly impressed with how smooth they go when the judge is controlling everything on the Zoom. You know, a lot of times when it's us or the court reporter or the defense and we're trying to orchestrate stuff, but typically we're so ready to rock when it comes time for trial. I can't think of really anything. I mean, there would be, I guess, some efficiencies of maybe going through the docket and stuff like that before the actual hearing starts. You know, sometimes we'll have a trial start at 1 and we don't even start testimony till 3:30, 4 o'clock. And then we have 4 witnesses. And I think that part, the back and forth about exhibits and stuff is a little harder over Zoom. But from a standpoint of, you know, getting it rocking and rolling, I think I'm always impressed with how good it actually goes.
Yeah, I don't
So-
have any complaints either. I feel at this point, I've actually done more Zoom trials than I have done live trials. And I've found that it's very easy, very straightforward. I can't even think of one thing that I would think would be helpful.
That's good to hear. We're going to stick with Bryan and Ryan. I think we're going to turn to pretrial stipulation.
Yeah, so we were talking before, just kind of in preparation, how pretrials aren't typically the most exciting thing to do, but in my view, and probably Ryan's too, it's typically is the most important part of the case. So it's easy to sort of fall asleep at the wheel when you're looking at a pretrial. If you think about it, you know, the way it typically starts is the claimant attorney prepares it, puts what they want in there, the way they want to word it, the way they want to present it, and then sends it to the defense. I don't know if you guys have a typical procedure at that point for filling out your portion, but I would expect that it involves probably talking to your client and doing that sort of stuff.
Yeah, I mean, I think with pretrials, I know they keep Bryan up at night as well, because it's one thing if we go to trial and we lose on, you know, a credibility issue, but dropping the ball in the pretrial and then losing on a technicality that we either did or didn't do in the pretrial is what really keeps you up at night. So I know throughout time mine have gotten more and more paranoid, for lack of a better term. You know, back in the day, before all the issues with 120 came up, you know, I would just put neck and back in the body parts, and those days are long gone. Now it's, you know,
I love seeing that.
yeah, now it's L5, S1, sprain/strain, and laceration to left thumb, basically copy and pasting whatever the most recent diagnosis is, because I don't want to get, you know, hit with the 120 and say, well, you said neck and back, and now you bought the entire, you know, 3-level fusion that Bryan's asking me for at this point. So the body part portion I've definitely beefed up throughout the years. And then with the recent rule changes, the motions to strike for lack of specificity are a big one. We had plaintiff attorneys or claimant attorneys before the rule change that are still doing this, where they have like a, depending on the firm, 14, 18, I think there's even one that's 24 just sort of boilerplate defenses listed in the affirmative defense section. So I've got basically templates for those claimant attorneys now for the motions to strike, because 99% of the time, either all of them or all but one of those defenses are irrelevant. But now if I don't do that, technically Bryan can raise whatever he wants at the hearing, so you definitely got to get out in front of those. But
Yeah,
I'm not sure that's being used as much as it probably should be.
We try to purposefully put things in there that are relevant. We take out the ones that aren't, but we want them to be somewhat vague, right? I mean, I don't want to necessarily bind myself to anything specific either. Like, for example, if I just say 120-day rule, I mean, I hope
Motion to
that
strike.
sticks. You know, I hope you don't ask me what I'm talking about and which body part or which, you know, part of treatment or condition or that sort of thing. So we do have boilerplate ones. Some of the defense attorneys in here have seen those. There's like 7 or 8 of them. We dwindle them down if we can. Sometimes we have to add extra stuff, especially if there's an objection. We have not seen a whole lot of the back and forth, motion to strike this, that. 9 out of 10 defense attorneys we work with, I'll shoot them an email and say, hey, voluntary limitation, I mean, do we really have to go through the song and dance of me filing a motion, which you know is going to be granted, because you have to be specific, and then you have to do, sometimes they say, throw me in that briar patch, but typically we try to we try to make it make sense. I always try to remind myself that that pretrial is something that the judge is going to turn to, and if it's a ridiculous looking pretrial that doesn't make sense, the judge is, I mean, your decision maker is the one looking at you like cross-eyed, so you want it to be good, and you want it to be something that if the case is appealed, that pretrial, I mean, the last appeal we had that was argued at the forum last year, the whole case centered around our pretrial. So, I mean, it can really come into the spotlight. So we put a lot of time into it, and those boilerplate things, I hope that there's no objection to them, but if there are, then we'll make them a little more clear. And
I mean, I think it's good practice in general to have, because I have a list of defenses for whatever issues are being raised that I kind of work off from a master list, but then whittle it down. But yeah, I mean, just no matter what the issue is, a follow-up appointment to a lumbar fusion, I get 24 affirmative defenses.
yeah.
Yeah, I'm probably going to have to
And
do
we
a
see
motion to
that,
strike on those.
we see that on the defense side too,
Of course,
even
yeah.
if it's just one simple thing, you get a whole page long with all the case law, and I'm like, it's not relevant, not relevant, not relevant. But I think it's also just part of the overall streamlined practice of things, it's easy now to copy paste and things like that, so I think we all get in the habit of being a little bit lazy doing that, but again, the pretrial is the worst place to do that sort of thing.
And I think everybody on both sides, I've definitely fallen in this trap where they kind of get more and more last minute, because some judges are more lenient with the 2 business days prior to the hearing than others, but the rules say one thing, but in practice, typically I'm getting the pretrial
100%.
2 days before it's due, maybe 3 days
Guilty.
before it's due. Yeah, and I'm guilty of that as well. But I think we probably both need to utilize doing a unopposed or a joint motion to reschedule those rather than frantically both of us filling out the pretrial and maybe doing a lackluster job.
And as a judge, I know that if I get one, I got the parties asking for 7 days, just because of something late breaking, they just need a little more time to complete the pretrial stipulation, I typically will grant that. Because typically the final hearing's a long way away anyway. So, I personally don't have a problem. I'd rather you guys do that and have that extra 7 days to kind of think about things than to feel rushed and then you got to go back and file an amendment, 10 days later.
And nobody wants to do a live pretrial hearing. I'm fairly certain. I showed up for one a couple months ago because it was too long and we just didn't have time. The judge was literally like, "What are you doing here?" Well, I didn't submit it, so I'm here. But he told us to take 5 days and submit it to him written.
I think you guys are going to talk to us also about verified motions and just your thoughts on those.
Yeah, those in the room that deal with me and the firm I'm at, we don't typically do those. I mean, we do 1 or 2 a year. It's not because we don't like getting fees and stuff, but it's just because we try to resolve it. From the claimant's bar, obviously it's a bit of a diminishing endeavor to dump a bunch of time into collecting a fee you're already entitled to. So we try to sort those out with ROCs and try to be reasonable, and whatever we present as our sort of initial demand, if you will, is something that's what's going to be sent into the judge at some point. So we try to make it something that's justifiable, reasonable, founded in fact, founded in evidence, all that stuff. But as far as the actual filing of the verified motion, I mean, I brought an example of one that we had to file recently with me, and we try to keep it as simple as possible and present more evidence later if we need to. So, I mean, we really just walk through the engineering factors. First of all, we outline clearly, and just so that there's no question about it, what benefits we obtained. And I hear stories about a lot of people getting caught up on that. Whether it's a benefit that hasn't been realized yet, or whether it's debatable whether you actually got a benefit, that sort of thing. I try to make it as crystal clear as possible. In this one, we went to a trial, prevailed on a pain pump. It's a 2-liner. That's the benefits we got. It's not complex here. We went to the final hearing. The judge granted attorney fees. There's no dispute about entitlement. Now here are the engineering factors. Here's our hours, our time. Here's our demand. And again, it's something that the other side's going to have already seen and hopefully have been, chewing with the client to hopefully come up with some authority, because, we don't need to go to hearings over fees. We don't want judges thinking that we're in such a great dispute about the fee aspect of things that we want to take up a bunch of the judge's time fighting about a couple $1,000s here or there when we can typically sort it out. So that's kind of our approach. Again, I guess the efficiency is really one of keys with me. That doesn't mean that if it should be 40,000, we'll take 30. But it means that, you know, this is one thing that I will absolutely jump on the phone as much as anyone wants to try to sort out the issue with the other side. And sometimes they'll email me and say, well, what about this, this, this? And I'll say, well, what about, you know, the fact that we did it, you know, quicker than average, and there were 6 depots, and we're board certified, or whatever the other details are that we can, I literally sometimes will say, please explain to your client this, this, and this. You know, sometimes people will forward that along, and it helps to know your OC, just like 99% of other situations that we deal with when we are trying to sort out issues. So verified motions are kind of only if we really need to. In all my practice, it could be different. I'm not sure what, maybe Megan has some insight as to how often you have to file
I'm filing them all the time.
And that's, you know, one other thing just before I finish, we are of the approach to kind of let fees linger unless there's a really good reason to go and collect it. I don't think
Statute of
everyone's like
limitations.
that. You know, one argument, at least an argument, I'm not so sure, I don't rely on it anymore, but it could keep the case open forever in theory. It's money in the bank is kind of one of the ways I see it. Obviously, I wish I, you know, took that 10-year-old fee from 10 years ago and put it in Tesla stock or whatever, but it's just another thing to hang over their head later if there's an issue, if there's a negotiation that's gonna take place, you know, you owe fees as well, those are still lingering, you know, things like that. So we typically don't pursue them unless we have to. If there's gonna be a private mediation for settlement and we wanna get it out of the way first, that's a good example of when we would say, okay, let's go ahead and do it. But like, you know, last month prevailed at trial, no idea when I'll ever go get that fee. It's, you know, one of those things, but maybe there are reasons in different practices to go get the fees sooner rather than later.
I just find that I don't get responses particularly quickly, so I don't like to let things linger they could linger for a year. I mean, I'd follow up every month or so saying, hey,
I
have
have
you had
plenty
the
of those.
opportunity to talk to your client? And I just don't get a response. And so after, you know, a couple months of that, I'm just like, all right, I'll prepare my verified petition. And I do spend the time. I feel like I spent an inordinate amount of time doing these verified petitions for fees, but then it makes things move a lot quicker. Once they have to respond, they usually come up with authority and we can resolve it pretty quickly. I always prefer to resolve it without having to prepare one because more often than not, they stipulate to entitlement, and so I'm not getting paid for my time to work on that. So I prefer to not, but I find myself more often than not having to do it just so that we're all put on a timeline, so they actually do have to reach out to their client to get authority.
From our end, responding to the motions are typically fairly streamlined. One thing I'm still seeing, and I'm a little surprised at, is the lack of proper verification on some of these. The rule wasn't changed necessarily, it was just kind of clarified and given more specificity as to the definition of verification, but I'm still seeing some that are just generally notarized, and that's an awkward position if you're either party and you get to the hearing and either your verified motion or your verified response is stricken from the record because it wasn't properly verified, and that's a tough conversation to have with the client on either end. From our perspective, it's obviously a statute of limitations issue, whether you're talking about the motion to dismiss for lack of prosecution, which is something, you know, we should be using probably more frequently, or at least the motion to compel the verified fee petition. That was the crux of the issue in Judge Newman's underlying opinion on the Stewart case that just came out, because they did that, they got the motion to compel granted, it was ultimately dismissed, and then the statute of limitations ran because of it. So especially with Ortiz lingering out there, however that's going to turn out, definitely something we should be utilizing probably more often.
Well, guys, what I want to do now, we're about 30 minutes in. Let's go ahead and turn to professionalism. And as I indicated, what we're going to do today is kind of hone in on the word professional to try to get our emerging leaders' point of view as to where things are at now and maybe where you guys see them going. I think one of the matters we discussed was dealing with law firms, hiring and retaining younger attorneys, younger professionals, and I guess I would like to hear from you guys as to how law firms, especially those of us with hair like me, that can maybe look toward your generation and the generation, frankly, that's graduated from law school like this year. What should law firms or state agencies or any entity be looking at to hire a younger professional attorney? Megan? start with you.
I think a huge thing for me is flexibility, and I would say that goes for a lot of my peers. So that I can understand, from a billing standpoint, you've got to get your number of hours in, and then on the claimant side, I find it to be a lot more flexible because it's not so much about how many hours you work, it's about how successful you are. So that's what I really like about the claimant side is if I need to go pick up my niece at, 2 o'clock in the afternoon, I can do that. I'm not, chained to my desk having to bill 10 hours a day or whatever it may be. And so I think flexibility and the opportunity to, go do the things that I need to do. One thing I particularly love about my firm is that our Fridays end at 3 o'clock. So, if I need to go to a business that's only open, Monday to Friday, 8 a.m. to 5 p.m., which is when I normally work, I think it's really nice. It's like a nice little touch that I really appreciated from my firm. So I can go to those businesses, at 3 to 5 o'clock on Fridays.
I would say I appreciate transparency. I also very much appreciate flexibility, but when I am interviewing associate candidates, I am fairly transparent with them that I say, look, you're trying to be an attorney. Being an attorney is a hustle. You're not hustling all the time, but it does require a hustle. It also requires you to be resilient, emotionally resilient. I've been on the receiving end of plenty of angry emails, plenty of angry phone calls, and it also requires a level of self-management and self-awareness. If you have those qualities, if you have the ability to develop those qualities, because they're hard to teach, then you can be a really successful attorney, certainly. You can be a successful professional anywhere, really. But one of the things that I try and at least open up any interview with someone is that it is a hustle. Again, you're not hustling all the time, but sometimes there's something that is going to come up that will require you to work a little bit longer and a little bit harder than you might otherwise. So I appreciate transparency. I definitely appreciate flexibility, and I've been given the leeway and trust to be flexible, which I think is important. But that requires kind of a reciprocal trust. I have to trust my employer, and my employer has to trust me. So that takes time to build. But I would say those are certain things that I definitely value.
The retention topic we were discussing kind of in the lead up to this, and in the middle of discussing this topic, my senior 6-year associate resigned. So this one's near and dear to my heart at the moment, unfortunately. The retention aspect and the acquisition aspect of attorneys in comp is difficult. The flexibility is typically the first question I get asked in an interview. Do you offer remote work? We are probably more inflexible on that than most firms. I think that's a balancing act when you're talking about acquisition, because for whatever reason, everybody coming out of law school, that's a focal point of theirs. But we're pretty staunch on our position, maybe to our detriment, because the fact of the matter is associates don't learn remotely. They're not going to. So much of the learning that they kind of undergo is organic. We do a new attorney training process. It's kind of an intensive 2-day thing where, half of it is, the work aspect, the billing, the tasks, and then half is the legal aspect. But so much of it is just they come across something in a medical record or a depo transcript, and you have that conversation kind of on the spot. And that's just not going to occur on a remote basis. So, it's probably a balancing act, maybe allowing a hybrid type setup for newer attorneys or, to retain current attorneys. So that's certainly an aspect of it. The other part with retention, and I've heard this phrase countless times, and it drives me insane. They don't want to get pigeonholed into workers' comp, which I always struggle with because they view it as pigeonholed. I view it as a niche or a specialty. I don't really understand the process. I'm sure everybody here has experienced it, where somebody leaves and they go start out in personal injury at the bottom of the totem pole in that industry, and the day-to-day is going to be so similar, but they're just trading one legal theory for another, and I always struggle with that. So I always try to impress upon them, like, look, comp is a specialty. The vast majority of people in this room have been doing it their entire career, and it's treated them well. You know, I've never gone anywhere. I've been with the firm since I graduated law school and clerked there in undergrad. So I think that's a issue you have to press home with them, that look, you know, comp will treat you well if you stick it out long term, and it's not being pigeonholed. It's having a specialty and really knowing what you're talking about.
Yeah, I was thinking the defense attorneys leaving might just be they finally see the light and start doing claimant work. I don't know. I don't have a whole lot of thoughts on this one just because we're a small firm and I'm where I'm at and I'm in my hometown and I have a family and everything, but I think that could be a big problem. One of the elements anyway is these younger people that come right out of law school, unless they're married and settling down already, they're not ready to settle down yet. And so maybe they're keeping feelers out there for other jobs. Maybe your particular firm wasn't their first choice. You know, those are the kind of things that come to mind. But from this on this particular subject, I don't have a whole lot of other insight. But I see the turnover from our end. You know, I see a different defense associate every 6 months or a year, and no matter who or no matter which firm and no matter how good the defense attorney is. So it's definitely, I don't know if it's always been like that, Judge, or if that's maybe a young person thing, because I do think, I mean, I like to at least pretend that, you know, the iPhone came out when I was a senior in high school. So I'm young, but I'm not, you know, 23. So
Younger than me.
so yeah, so I always kind of like to say, yeah, hey, I was part of that generation where my parents would say, go ahead and, you know, be home by dinner time and that sort of thing. I didn't have a phone growing up or anything, so it could be generational or age related, but for all I know, there's always been a retention type issue. I think it's just that the demands are different, you know, kids wanting to come out and have flexibility. I remember when I was in law school, my dad said, don't you dare ask about vacation time in an interview. You know, and now it sounds like one of the first questions is, what's the flexibility like? It's just a total paradigm or perspective shift.
I know personally, Bryan, I think things have changed. I mean, I'm speaking for myself. I've been out, you know, law school for, we won't discuss the length of time, but quite a while. And I think that it has changed. I think the younger people are coming out of law schools and they're just demanding more. And I think there's a different expectation than we have when we came out of law school. I think that law firms and agencies or anybody hiring younger attorneys have to be mindful that, especially those of us who, you know, got this kind of hair, you have to be mindful that you're just hiring from a different pool than we were hiring from in the 90s or the 80s or whenever we began working. And that's just a different mix. Bryan, I'm going to stick with you because I think we want to change gears now. We want to talk about maybe where the panel sees workers' compensation going in the next 10 years, whether it be technology or staffing or what have you, and we'll work our way back.
Yeah. You know, that's such a great question. I think that the trend that we're seeing now is going to continue as long as the overall trend continues with the way tech works and the way, you know, it was actually awesome to hear. I don't remember exactly who said it, but I think it was the chief judge that spoke at the very beginning of the conference, something about no interest in having a centralized, you know, all the judges in one room and across the state, you know, handling things across the state, but from one room. I think that's so important. I see the practice, even in my short 8 years, turning into something where I could be in Port Charlotte and I could be handling something in Pensacola for a client that lives in Fort Lauderdale. You know, the whole thing, it's bizarre to kind of see it that way. And I think that a lot of people are ahead of the curve as far as business goes in being ready for that. And, you know, probably we're in Little Port Charlotte in Southwest Florida, and we like having local clients, and we like knowing our doctors, and we like knowing our judges, and we like seeing people in person and stuff like that. But that's not at all the way that things have been going generally. So I think the practice is going to continue to trend that way, especially as technology gets better, especially as marketing gets better, targeted ads get better. I mean, again, I have nothing bad to say about people that handle cases throughout the state. It's just not our style. And again, I think to compliment them, I think they're kind of ahead of the curve as far as dealing with that. And I'm sure there's defense has a similar thing. You know, you probably used to be limited to South Florida, and now it's piece of cake if you had a client up in Tallahassee. Okay, I mean, you guys have a firm up up there in office, but yeah, that's what I see it continuing, I guess, is the short answer.
From a technological standpoint, I don't think there's any going back. The idea of driving down to the JCCs or up to the JCCs for every mediation now seems mind-boggling, and I don't know how we did it.
It is crazy. I used to look forward to that $42 mileage check, though, when I was early on. Man, that was a big deal. And I sometimes got lunch out of it.
I didn't get that at any point, so I never had that sort of carrot dangle in front of me. But that part, I don't think there's any going back on from either side. Because I know everybody's experience. You'd get down there, and then the notice of resolution was filed, and you'd turn around and drive back, an hour to my office. Those days, I don't think are going back. From a 10-year perspective, though, I think there'll probably be a fairly dramatic change, because the time period between Emma Murray and Castellanos, nobody was really hiring. So there's a pretty large age gap in comp during that time period. There don't seem to be a lot of 40, early 40s, late 30s type attorneys in comp. Everybody either existed pre-Emma Murray or they were hired, right after Castellanos. So I think there will probably be kind of a changing of the guard over the next 10 or 15 years as that generation retires and lives their best life, and kind of leaves us to deal with, comp in its entirety.
I agree on the technological front. I actually think that attorneys everywhere will have to be a lot more nimble when it comes to base technology. And I'm not talking about Zoom, certainly, definitely have a handle on it, but being able to navigate an e-filing portal, being able to format your own documents, being able to do kind of a lot of the stuff that usually gets farmed out to legal staff, because sometimes your staff isn't going to be there, or they might be out with a serious medical condition. I've had that happen to me where you bet I'm 100% less efficient, but I have to know everything that person is able to do so that I can continue working, because a client somewhere, somebody somewhere is still expecting me to do my job. I still have to do it, right? The work doesn't stop, doesn't go away. And you would not believe the really odd gap between just understanding technology from people that are 10 years younger than me and 20 or 30 years older than me. I've had legal assistants who are significantly younger than me that ask me, hey, the colors on my monitor don't really work that well. It looks kind of purple. And I'm like, well, did you touch it? Did you touch the monitor? Did you look for some buttons? Did you click around? There's this very interesting apprehension to not be curious or not take a risk because you're so afraid of making a mistake that you can't turn back. And so I think that attorneys will have to be a lot more nimble from a technology front, because it will just be a requirement. You might not be able to find people to help you do your job, and so it's going to require you to be more of a jack of all trades as a human being, as opposed to, a specialized attorney that focuses on pleadings and focuses on arguments. From a macro standpoint, I'm with Ryan in that I think not only comp, but I think the legal industry will change significantly, just
Elaura,
because of technology.
You mentioned something last night at dinner, and it stuck with me. And you're saying, even at your generation, and you're still very, very young compared to me, but you're running into assistants that you guys are hiring, and the lack of a better term, you could call them the app generation. Like, they're used to looking at an ad and pressing a button and everything happens, but distinguishing the fact that you guys can still go onto a laptop, keyboard, and control delete, which some of them know what that means. And so even there's a disparity between you guys and the 21, 20-year-olds out there. Yeah. Interesting.
I interviewed an associate born in, to put it in perspective. So the emerging leader, but I'm decades removed, so that was a real blow to me. ago. So yeah, there's a generational age and then the generation coming, because yeah, somebody
Wow,
entirely different lives.
that's a 4-year-old attorney?
Yeah.
Yeah.
Thing I gave, that was that next time I have somebody tell me that I was doing clerical work in my, I'm going to call you as a witness. Say that paperwork and that was attorney time.
Yeah, but you know, I paid for that time.
Megan, what are your thoughts on the next 10 years?
I think it's going to continue this trend. We're never going to go back to the pre-COVID time. I think things will continue to on Zoom. It allows us to do things faster. It allows us to reach more people. I have clients in Pensacola and I have clients in Miami and hearings, you know, with those areas the same day, which obviously would be impossible or close to impossible, you know, COVID when we had live to hearings. So I think there's a chance of going to that pre-COVID. I think especially claimant lawyers, you know, will continue that if practice is open to clients from all across the state. I think they'll continue to get busier as we are specialized in Orlando, but we represent people from the state. We're getting more almost than we can handle. So I think it's going to continue to trend and be to kind of, you know, work with it. I mean, our schedules are busy and, you know, we see hearings, we see physicians, all sorts of from the state on the day. So I think we're just going to continue that way. And tech will only continue to advance. Hopefully there's something a bit better than Zoom in our future that I've heard of, but, you know, maybe something that's a little bit easier to handle. So I would guess that would be in our future.
I think you're probably right. I'm going to stick with you, man. I'm going to go right back to mine. Had a recent instance, as you probably read in the Florida bar, about, lack of a better term, work. I think the bar has realized that this affects attorneys. And from your perspective, we got about 10 minutes left. I'm going to leave a few minutes for questions if anybody has any of our leaders. But what are your thoughts about the importance of work-life balance in practicing?
I think it is extremely important. Of course, I understand the importance of, you know, paying dues and work. But I also think that especially in this tech age where if a young lawyer or isn't offered that work balance in their, you know, anyone can get a remote job these days, right? And so if the job is, they're going to move on to something that is a lot more flexible. I think life balance, the opportunity for, you know, going to another job quickly. I think the balance is really important. Even though it seems silly, you know, especially for lawyers, I think it's a really important thing to emphasize that it does care about, you know, your well-being, life balance. And so I think, you know, vacation time, nobody wants to ask, especially interviewing, you know, for a new job. But I think if you're looking to retain young lawyers, maybe upfront about that. Oh yes, we want our clients, or we want our attorneys to take time for themselves. We want them to be as possible heads. I think it would be a good, you know, point. It does for me. So that would be a point whenever you're trying.
I agree. At the end of the day, if you don't take care of yourself, then how can you be expected to put your best forward and represent somebody else to the best ability? So it comes down, I think attorneys experience this kind of friction that's supposed to be lawyer driven, that the bar and professionalism us. We're 24/7. Does that mean that I am 24/7 on call for a client? No, I'm not. So there's this friction between you're always an attorney. A second, you need to put in boundaries so that you don't overwork yourself, burn out, and counsel, young associate, or your staff, for that matter, over something that really, think that's really important, and sometimes it takes a mentor or someone who has so much more experience than you to drive that point home for younger attorneys and to tell them it's okay to do this. You can, the work is still going to be, it's going to be all right. It's okay to set a boundary. You don't have to be there all the time. Please do your desk. It's not going to make you an attorney, I don't think. To be a well-rounded person to really be the best attorney you can be.
I struggle with this one, personally. It's I think, a little more difficult because it's email-based rather than they call your office, call the secretary. And in a post where adjusters are remote, I've got adjusters working at 5 and I've got adjusters work until 10 p.m. So I'm getting emails that entire time, but I want the same level of responsiveness service for myself. So it kind of forces you to expand your availability hours. It's difficult to disconnect from that aspect. But from an associate, at the end of the day, we are still practice litigation attorneys, and I think sort of this expectation or understanding from some of the graduates now that law school is at the finish line. It's really not the case. You're just starting nothing and you're starting your career, and that's because theoretically you don't have wife and kids to build that aspect of your career. So we try and impress associates like, look, this is be a 4-week job. You're a private insurance defense with billable hours. So that's just kind of the process, and some people understand that, kind of welcome that challenge. Some people don't. I'm not sure there's a cure for that, but balancing, a on-call type issue, I think everybody has to do nowadays because clients don't care. And Judge Walker about this in the lead up to this, and he's like, well, I'd get to the office back when I was practicing, open up my mail, and I had 24 hours or days to respond. That is not my clients be upset, 2-3 hours go by and you don't get substantive response. Sometimes they're emailing it Friday and it's the 14th and they need a compensability and you get kinds of information. You got to drop what you're doing and their compensability analysis. So that act from a standpoint at least is difficult, and I don't know that there's really any right line at this point.
Struggle with this one too because anxiety if I don't know what's going on, but this is probably the longest I haven't checked since I've been in Tallahassee. So we have our challenges on the claimant side. For me, it might be a Saturday morning and that $1 million case calls the office. What am I going to do? Let go call Morgan or whatever. And I like my mornings, but anyway, but we have our own struggles, problems, difficulties with the same thing. I can't the importance of that. Try and maintain that work-life balance because you can get burned out, and probably everyone has been burned out. And got news for younger ones here that don't have kids. I mean, it's just going to get more difficult to balance. So, so I do think it needs, an emphasis on that. I think one of you over there said you can be your best self if you're not prioritizing that sort of. If I show up in, an hour late to the kids' game, or vice versa, if I show up an hour late because I was late bringing the kids to school, whatever it might be, it's just you've got to have all. Sure.
I flew up here yesterday from Fort Lauderdale, and I was sitting next to Andy Borer on the way up, so we chatted the entire way up. And both of us, like clockwork, we didn't even think about it. As soon as the plane landed, we both dug into our phones and started answering emails. And he was like, "Same life, huh?" I'm like, "Yep."
That's a perfect note to end on. What we're going to do, guys, we got a few minutes. If there's any questions from the floor, just feel free to ask the panel. I know at 11 o'clock, I think there's a 10-minute break, Judge Hedler. So any questions of the panel?
So Zoom allowing attorneys to be in more places at once, certainly allowing us to put more hours in the day. How have you adapted your practice and sort of what you tell your staff, particularly with staff members who may not have been around for that travel time era where they had the calendar for you, and those potential conflicts maybe don't even get rescheduled?
I sent an email this Monday because there's this just in the Zoom area our staff jump right into things immediately with no break. I literally had to send an email. I need a moment to the restroom, breathe, think about something. So I think everybody has to improve on their staff. Like, no, I jump from an adjuster desk to a motion hearing to a mediation back to back to back in 3 hours, but they don't see time anymore, so they see a gap in the calendar. Plug it. I'm like, guys, please.
It's telling, I also just had this conversation with my paralegal. I mean, it probably had 7 depositions last week, and I mean, it like just 2 a day. I mean, it was wild, and so we had to sit down and have a conversation about, I need like at least a full day to prepare, and so you need to not, even though my calendar is open, you need to not schedule anything for that time frame, because it's about getting your staff to understand that there might be free time, but that's not actually free time.
Any other questions? We've got a
Good question.
couple of minutes. All right, everyone. Thank you so much. Enjoyed it.